Welcome to Deals and Disputes with the West Webb Law Group.
Hello and welcome to Deals and Disputes with West Webb Albritton Gentry, where we will explore the ins and outs of professional liability and the legal risks that can affect professionals across industries. I am your host, Kevin Rosenquist, and our guest today is Gaines West, a seasoned attorney with over 50 years of experience in litigation, arbitration, and dispute resolution. Gaines is a founding partner of West Webb Albritton Gentry, a firm he and John Webb established with a mission to provide sophisticated legal representation, attract top-notch talent, and create an environment where work-life balance is a priority. And over 4 decades later, that vision continues to guide the firm's success. Welcome to the show, Gaines.
Thank you.
So can you tell the listeners about your experience and your 50 years of experience in representing clients who are facing professional liability claims?
Right. Not all of those years were doing that, but a good substantial number of them were. I've been representing all kinds of professionals, lawyers, doctors, realtors, engineers, both prosecuting and defending professional liability claims. So I've had a pretty good run at seeing most all sides of this particular issue.
I bet. What exactly is professional liability, and what are some of the most common professions that deal with these potential claims?
Well, if you can think of a profession, you've got a professional liability issue that could arise. These claims are made because, clients or customers feel as though the professional has not done what they should have done. They've fallen below a level of competency or reliability for that particular profession. And that's why they consider bringing an action. It starts out sometimes in a disciplinary process against a professional within the administrative agency of that profession. And it can then end up in a professional liability lawsuit because usually discipline doesn't involve the award of damages. So if the client or customer wants to be made whole through a money damage model, then that's going to follow with litigation. So you can do a discipline action against a professional and also a professional liability action. And most of those professional organizations will require some administrative processing of claims, but those don't necessarily have to precede a liability claim in a lawsuit. They can go on equal tracks, or one can start and end and the other can start and end.
Okay. How does negligence play a role in professional liability claims? And are there other key factors or breaches that tend to trigger these lawsuits?
That issue of negligence is a little bit of the core issue for a liability claim. And that negligence standard is usually either brought forth in statutory requirements or common law requirements that this professional is required to operate at a certain level of professional competence. Mm-hmm. And the allegation is that they fell below that level, and it could be due to negligence. Oftentimes that's the accusation, but it could be due just simply because they're not competent or they haven't considered all of the issues necessary for their professional undertaking of the activity that they're being sued for. But mainly the issue of negligence comes along when there's a duty and that duty has been breached. And the focus is all about whether the professional actually competently handled that matter, committed no negligence, and provided the activity that they were hired to do appropriately. When I'm defending that, of course, that's what we're talking about, that there was no negligence or any of the actions taken were well within the standard of care for that profession. If I'm prosecuting that claim, of course, I'm out there throwing darts at the professional saying that particular action of that professional over the course of their representation resulted in damages to my client, and it was caused by the negligence or the failure to follow the standard of care for that particular profession.
Okay, and you mentioned that you had a few different professions, or that every profession can be in this fall into this category. Who do you represent most?
Probably doctors and lawyers on both sides. Probably less frequently realtors. Engineers also are invited to that party as well. And, I say that a little jokingly, but unfortunately, my clients, when they come to me when they've been sued or they've had a discipline action taken out against them, generally quite emotional about it because it's personal. It's a personal attack. And some of the worst responses I've seen have been by that professional deciding they do it on their own. And they would start that representation and soon have to find help quickly because it's just too emotional. It's too personal. And they may really be a very logical, together kind of professional, but when it comes to defending yourself, it's a whole different ballgame. When someone comes to me and they've been sued and they say, do I really have to answer all of these issues? And I said, this is an invitation you can't turn down. Mm-hmm. It's something you're going to have to respond to. But I'm going to be here to help you, and we're going to figure out how to get you through this. These kinds of actions seem to last forever, too. I know it seems like my clients who've been accused of professional malfeasance seem to get a lot less sleep. They seem to call me a lot. They want to know what's going on a lot, which is certainly understandable. But what I try to do is coach them through this and say, look, this isn't going to last forever. We're going to get through this. But there's certain things that have to happen as we go through this.
If a professional is faced with a lawsuit, what should their first steps be in terms of defending themselves legally? And how important is early intervention?
Well, early intervention is really important. And the first thing they ought to do is get help, not do it themselves. I think that would be the worst response. And I'm not just trying to feather my own nest. I mean, there's plenty of competent attorneys out there to represent that professional, but they need to get professional representation. Because when you try to take it on yourself, as I said earlier, it's just, my experience has been, it's way too emotional. It's way too personal. And when you're dealing with your livelihood, that tends to go up to the very top of your attention calendar and to the detriment of all the other work that you're doing. But one of the first things that I really want my clients to do is get their file together. I'm hopeful that it's a professional who I've worked with over time, because I will have already advised that professional to make sure that they're documenting their file often and well. What I find to be one of the most difficult cases to defend and easiest cases to prosecute is when there's a very thin client or patient or customer file. And what I mean by that is, when we were in kindergarten, we were all told, before you play with that next set of toys, you need to put up the set of toys that you have. And what I do with my clients is to say, look, what that means in terms of your professional activity, if I can bring a real simple application close to home, is before you go on to that next project, you really need to document what you did in that last project, put up your toys, make sure that they're all in place before you take out that new toy, that new object of your attention. So that client who comes to me who has been sued or threatened to be sued or has a discipline action filed against him or her, the first thing I want to see is their file, and I want to see all their documentation in that file. Because, I find that my clients are plenty smart enough. Obviously, they wouldn't find themselves in professional activities if they weren't. They're plenty smart enough. So if someone accuses my client of professional malfeasance of some kind, then we're generally smart enough to figure out, what the story is behind why it isn't. That's what I'll oftentimes hear first from my client is, this is why this is all wrong, and this is what I did. And so what I want to do is look at their file, their documents, and make sure that their documents tell that story, not just them telling that story. And it can be, explained to my clients, it can be documentation in the form of, notes with your handwriting that only you can read. That's fine. I don't care. But what I want to see is a series of notes to your file that will tell a story for us over the term of the representation, or the period of time that you were treating that patient, or the period of time that he was or she was your customer. It's those kinds of files that will tell the story for me in defense of a claim that make it believable. And it generally works out where we can show that what was done was not a professional malfeasance, or didn't amount to negligence, or the standard of care was met. So that's really, really important. Anytime my clients come to me, I say, look, if you don't have your file together that way, I need you to go back and do memos to your file on what your memory is now, and give dates to them the best you can. We'll never represent that you didn't go back and do that, but it's good to go ahead and get something in your file that will link all of those things together.
I've been trying to get my son to put away toys before taking out new ones for a long time. So I hope you have better luck with the lawyers than I do with him.
Most of the time I don't, but tell your son that there's a good reason to do that, and he can apply it all of his life.
I'll see if I can get through to him. So, okay, so what's next then in the process? So you've got them getting their paperwork in line and all that. So how does the rest of the case generally unfold?
Okay, just generally, professional liability suit is like any lawsuit. There's really no difference to it. It starts with a petition. We get the petition, or we file the petition if we're prosecuting it. And that lays out your summary of the case, of what you believe. If it's in state district court, we have just a pleadings requirement that says you don't have to go into great detail when you plead this case. So it's just notice pleadings. In federal court, it requires a bit more pleading art form, because if you don't, you can get your case dismissed really early in a federal case. So it depends on where you are and what form you're in. And I've practiced, of course, in both state and federal forms over the years. So the first thing that happens is we get the pleading in, we take a look at it, we look at the file, we get together our discovery documents. The documents are going to respond to requests for interrogatories, which are questions, or requests for production, which is for materials out of the file. We look at all those. So the case starts out with that petition, and then you go into the discovery phase. That lasts a good long while generally, and costs a good deal of money, unfortunately, because it requires the taking of depositions. Sometimes it requires a protective order to protect the names of the people involved. It requires in the depositions, for state depositions, they can last no longer than 6 hours each. In federal depositions, it's 7 hours each. But to take those depositions is generally a 9 or 10 hour prospect, and it takes many days to get ready for them. And then how you fit into that, the whole process of discovery is a very integral part of the litigation. And let me back up and explain it this way. I was in the Navy for a while, and I learned critical path method, CPM, it was called back then. And what you do is you start out with your goal and you start backwards. And that's what I do in any litigation, whether it's liability litigation or any other kind of litigation. I go to the very end of the process and look and see what I need to prove to a jury or a judge when I am representing a client. And you've probably seen it on TV, but there's something called a jury charge that goes to the jury after the trial is completed. So when I first get a case, I'm going to be really focused on what that jury charge must contain. And really a jury work, or a judge, if it's just to the bench, works like a real slow computer. We just ask yes, no questions. But in order to be able to ask yes, no questions, you have to know what the elements of the causes of action are, whether it be negligence or some other cause of action. You need to know the elements of that cause of action, because that establishes all of the discovery I'm going to do. In other words, when I go in and ask questions in a deposition, or ask my questions in interrogatory form, or requests for materials, they're all going to be centered around supporting the questions I'm going to ask the judge to give to the jury at the end of the trial. Because here's what happens at the end of the trial. Lawyers are worn out after the trial's over, and we're all kind of sitting around with the judge, working on the jury charge together. This is going to be what goes to the jury. And I want a question to the jury, and the other attorney will say, well, Gaines doesn't have any evidence on that, judge, to support that question to the jury. And I said, oh, yeah, Gaines does, because I remembered when I first started this case way back when, these are the elements of this professional liability claim. And I have evidence on this element. So, judge, this is why this question gets to go to the jury. That's really an elementary look at it, but it starts like almost a bell curve. If you start out with your petition, the discovery is kind of the fat end of that curve. And then the trial is at the very end when the jury gets that question. So I work closely with my client, whether it's a lawyer, doctor, engineer, realtor, nurse. I do a lot of nursing cases as well. I work with them through the discovery phase, because it's very important that we get the answers to those questions right. Really only have one time to give those questions. And then in deposition, it's very, very important that they understand the questions that are asked and they answer those questions. I prepare my clients this way for a deposition. I usually send them home if they're married or have a partner, and say, look, why don't you all try to ask questions to one another and answer only the questions that's asked. That's one of the focus points in any litigation is when my client is deposed, I want them to listen carefully to the questions that are asked and only answer that question, because during the discovery phase of a trial, it isn't that time that you're going to tell your whole story. You're just there to answer the questions of the other attorney. It's an art form. It's really kind of hard to do. So I really, kind of get them really prepared for those depositions because it's very important. I left out
I like
another
to talk, so that would be hard for me.
Yeah, it would be. And especially it would be hard for you. And let me explain why it would be hard. If you're in a deposition, and my clients would usually come out after the first hour of the deposition and ask me how I'm doing. And I'll usually say, well, I guess you like this a lot. And they said, no, I don't like this. And I said, well, because you're talking so much and you're answering beyond the questions that's asked, you're giving the other attorney lots of fertile ground to plow that he or she hadn't planned to plow before they got into the deposition. So you need to remember to just listen to the question that's asked. So that's really key and focal. Another thing that I forgot to mention in this bell curve, petition, discovery, then trial, is there'll be an opportunity for one side or the other, or both sides could do it, file a motion for summary judgment. And that is, you take the facts and the law and you tell the judge, assuming everything in favor of the plaintiff's position, judge, this case is a matter of law, doesn't need to go to a jury because there's no material issue of fact for a fact finder to decide. So we need you to take this out of the process and award us the win right now instead of waiting. So there'll be an opportunity. It's called a dispositive motion, and there'll be an opportunity to do that. And one other thing I want to mention before we leave, just this description of any kind of a trial, in especially involving professional liability issues, is mediation. There's an opportunity for a mediation to occur. Sometimes a judge will even order mediation, even though the judge can't order one or the other party to settle the case. They can order you to mediation. And mediation is so different than arbitration. So many people get mixed up with arbitration and mediation. Arbitration is like what you see on TV with Judge Judy. The two parties that have come in to have Judge Judy adjudicate their matter have signed a contract with her that said, we're going to follow whatever you tell us to do. Well, a mediation is not that. A mediation is where we have a trained mediator. It doesn't have to be a lawyer. Oftentimes it is, though. A trained mediator come in and lead both of the parties to a place where they voluntarily decide to settle the case. You mentioned at the first of our session that I've been practicing law for over 50 years. This is my 51st year. I remember years ago, we started talking about alternate dispute resolution, or ADR, which is mediation. And I thought, that's funny, because when I first started practicing law, alternate dispute resolution was a jury trial with a judge and a jury, because before then, we used to settle our disputes by taking two pistols out at 6 o'clock in the morning, drawing them, going, 30 paces and turn around and shooting one another. And ADR was a jury trial. Our Supreme Court had a great new idea, which I thought was dumb at the time. But since then, I found I was the dumb one. They aren't, obviously. But the idea was they were hearing that many of the combatants that would wind up in appellate courts or even before the Supreme Court would say, if I'd have heard that or known that, I would have never gone this far. So the Supreme Court says, look, we think that ADR in the form of mediation is something we ought to really embrace. And for the last 30, 35 years, we found it taking center stage in our litigation, in all of our litigation. And today, we settle as many as 70, 75% of our cases through mediation rather than going all the way through the courthouse. Now, there are some cases that have to go through complete litigation, but mediation is a way to resolve a dispute. And I will tell you that I tell my clients, particularly my professional liability clients, that the best way to settle a case is try a case. And that sounds to be antithetical, but truly, the best way to get a case settled is to get it ready to try it. Because if you get a case ready to try it, you're ready to try it. You will try it, and you're not going to be sad that you weren't prepared. If you get a case prepared just to settle it, you're not going to be ready to try that case. Right. So I'm always looking at a parallel path between getting a case ready to try it and settling it, looking for those opportunities to enter into either mediation or just through settlement conferences with the other counsel. But those opportunities come during that bell curve of the beginning of a lawsuit to the very end of a lawsuit. And you just have to be aware of them, listen for them, and see if you can't get this resolved. I will tell you before we leave this mediation topic, the good definition for a successful mediation is the party who wants something gets less than they want, and the party who's giving something gives more than they want. Everybody leaves a little bit mad, but the thing is settled. And when I say the thing is settled, one of the problems with any litigation, including professional liability litigation, is that you get to the end of the trial, the jury makes the determination, you think, wow, we won, it's over. It may not be, because there could be an appeal, and then an appeal after that. It can be very debilitating financially and emotionally, not only on the person involved, the professional involved, but the professional's family, because it really diverts a lot of the energy and attention.
Absolutely. Yeah, I think that's a great point about making mediation work when you can, certainly. All right. Well, thank you for tuning in to Deals and Disputes with West Webb Albritton and Gentry. To connect with Gaines and the team, visit westweblaw.com, and that is web with 2 B's in it. And please like and subscribe to our channel and leave us a review. Gaines, it was really great talking with you. Thanks so much for the stories and the insight.
Thank you. I enjoyed it and look forward to visiting again.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.